Vallejo. Good morning.
Good morning, Your Honors. May it please the Court. Assistant Parapublic Defender Vivian Marrero on behalf of Mr. Reyes-Santiago. We raised three issues on appeal, but we would like to first address the issue regarding the reasonableness of Mr. Reyes-Santiago's 420-month sentence. We are aware that a defendant that challenges the reasonableness of a sentence faces a high hurdle, but the history in this case and the sentencing judge's four initial orders reveal that the motive in rejecting Mr. Reyes-Santiago's drug stipulation in the plea agreement was a subterfuge to mask the real motive in rejecting
Counsel, did your argument depend on our accepting your argument that the judge was disingenuous about the motivation for the sentence?
Yes, Your Honor.
Could I just, to follow on that, suppose we simply thought there wasn't a good explanation for the disparity. Is that a possible outcome, or do we need to conclude that he was motivated by an impermissible consideration?
Well, Your Honor, can you repeat the question?
Yeah. Is it enough for your argument to succeed if we were to conclude that the judge didn't give a reasoned explanation for why your client got the higher sentence relative to other people in the conspiracy? Or does your argument depend on us concluding that the judge had a impermissible motive for imposing the higher sentence on your client?
I would go with the later. The judge had an impermissible motive. The disparity in this case was based on the rejection of the drug quantity stipulation in only two defendants, and these two defendants were the ones that were acquitted in the Pajaros massacre trial. So it's not regarding the criminal history comparison or the difference between the PSRs. The only two cases where the base offense level used in the PSR and to impose the sentence that included the entire amount of the drug quantity in the conspiracy that lasted 5 years was in Mr. Reyes-Santiago's and in the number one that was also acquitted in Pajaros massacre.
But that could be true, and also it could be true that there would be a reason for your client to be subject to a different drug quantity amount than other people in the conspiracy if he had a different role in the conspiracy than the other persons who were charged. So, as I understood it, Judge Fuste thought that your client was the lieutenant to the number one figure in the conspiracy. That was not true of other people. So why isn't that a good ground for the distinction?
Well, we submit that when the judge mentioned that he was a lieutenant, it's not supported by the record. The PSR or the testimony of the witness that testified at the sentencing hearing, the PSR did not mention anything egregious that Mr. Reyes-Santiago was different from any other manager or drug point owner. In fact, he was number 9. And the judge followed the drug quantity stipulations in 3 of the leaders of the conspiracy that were higher in rank than Mr. Reyes-Santiago. So when he mentioned that he was a lieutenant, there's nothing in the PSR or in the testimony of the cooperating witness that says that he was in fact the right head of number 1.
Well, one possible difference, if you could just explain it, would be helpful to me, is that as I understand it, the particular housing project that your client was responsible for or was involved in was the housing development that the leader, number 1, according to Judge Fuste, was personally managing, and that was not true of the other defendants, right? That the stash house, he says, was your client was involved with that stash house with number 1 in a way that no other member of the conspiracy was. So could you just comment on that ground that Judge Fuste gave for distinguishing your client?
Well, I would disagree as to the fact that he was the leader in that stash house. He was in the indictment and the evidence presented by the witness and in the PSR says that he was just as the other managers and drug point owners. He did run in this particular case. He was allegedly the owner of the marijuana, and the record also mentions that he sometimes served as the runner of some sort of cocaine when the number 1 was not available. But runners are even lower in ranking than managers and drug point owners. So I don't think that that differentiates Mr. Reyes-Santiago enough in order for the judge at the sentencing hearing just to go and completely reject the drug quantity stipulated in the plea agreement and go from a base offense level of 28 to a base offense level of 38. That did not happen with anybody else in this conspiracy. Only as to number one, yes.
But isn't it commonplace in agreements like this that stipulated drug amounts often bear no relationship to reality? I mean, they are driven by the need to make a deal. And so for a judge to be skeptical about that stipulated amount, that's not surprising or wrong, is it?
It's not, Your Honor. It's not. But in this case, he did follow the drug quantity stipulations of leaders that were higher in rank than Mr. Reyes-Santiago. So that's where the disparity comes at issue. Not in the total guideline, because the base offense level was calculated regardless of the defendant's criminal history. He bumped it from 28 to a 38. And he got the highest sentence, 420 months.
Could you just explain to me about how the conspiracy worked? So is your understanding that if you were a leader of the organization, so one of the 5 leaders, which I understand your client was not designated as one of those 5 leaders, but if you were one of those 5 leaders, here's 2 possibilities for how the conspiracy could work. You tell me which is right. One is I'm a leader, but I only see a fifth of what the conspiracy does. I'm a leader in my sector. I do my housing project. That's it. Another possibility is all the leaders would have known everything the conspiracy was doing. Which is it? I mean, is it the idea that if you were a leader, you would have known the basic total quantity of the whole conspiracy?
Yes, Your Honor.
And what suggests that in the record that would help us come to that conclusion?
Well, in the record, at least in the PSR, there is a table that says the entire amount of drugs that were distributed throughout the entire conspiracy, throughout all the housing projects, not only the marijuana, but the cocaine, crack, and heroin. And that table was used in the base offense level of Mr. Reyes.
Did each of the 5 leaders of the conspiracy share in the profits of all of the drugs of the conspiracy?
Well, I submit that they did, Your Honor.
And does the record show that?
Yes, Your Honor.
If you could help us with where we would find that, the best evidence of that from the record from your point of view, that would be helpful. Even if I don't know if you can do it in a follow-up letter or something, just for saving time. You don't have to do it right now, but that would be.
File a letter notifying the opposite counsel in 10 days.
Very well. Thank you, Your Honor.
And the government can respond in 5 days.
Our position is that if this table with the entire drug quantity that was distributed during the 5 years of this conspiracy was included in Mr. Reyes-Santiago, it was not at least considered in the base offense level of any other co-defendant in this conspiracy except for number 1, which was also acquitted in the Pajaros trial method.
And was that table in the co-defendants' PSRs?
Well, we don't know, but when the judge imposed the sentence, it followed the drug stipulated amount in the plea agreement. Therefore, if it was in the pre-sentence investigation report of the other co-defendants, that entire amount was not used to calculate the base offense level as the foreseeability of the drugs that were involved in the conspiracy. But this was the case of Mr. Reyes-Santiago. He started at a level of 38, Your Honors. Also, Your Honors, the judge stated for the record that rejecting the drug quantity stipulation in Mr. Reyes-Santiago's case would shock his conscience, but that is inconsistent with accepting that drug quantity stipulation for the leaders that are higher in rank than Mr. Reyes-Santiago. Also, he followed the drug stipulation amount in the owners and managers of the conspiracy, such as Mr. Reyes-Santiago, but rejected that stipulation.
In the history of this case, what I may have missed it in the briefing. What triggered the judge's particular interest in reevaluating the drug quantity in this case? What was the explanation for his particular interest and his insistence that a witness be brought forward to testify about the drug quantity?
If I may, Your Honor,
Please.
the judge initially stated that he wanted to hear evidence at the sentencing hearing regarding what happened at the Pájaros Massacre trial. He issued 4 orders as to that. Then, thereafter, he changed his mind and said that he was not going to consider the Pájaros Massacre, but still he wanted to hear the testimony of the witnesses in regards to the drug quantity stipulation. That's when the parties were made aware that he was going to use that witness in order for the witness to testify as to the drugs that were distributed throughout the entire span of the conspiracy.
Was there any suggestion that the judge was concerned that your client may have been involved in that notorious shooting in front of the courthouse in Monterey?
Well, he was not involved. However, there was one order that he makes reference to that incident that he was included in the order, but he had nothing to do with it. Mr. Reyes-Santiago had nothing to do with it. The only issue was the Pájaros Massacre trial.
That wasn't the question.
Right.
The question was whether the judge somehow joined both the issues, both questions.
Yes, Your Honor.
Do you want to answer it?
I believe that he did at one point.
Why did you say that?
Because he wanted to, in the orders that he issued, he wanted to hear testimony of both incidents, of the Pájaros Massacre trial and of the Pitufos murder that occurred in front of the courthouse. And didn't differentiate who was involved in the Pitufos murder or in the Pájaros Massacre trial, just the 3 defendants.
How does that appear in the record?
It's in the orders, Your Honor. He issued an order as to that effect.
All right, in your letter, would you please point out where it appears?
Yes, Your Honor, I will.
So if I follow, there were only 2 people in the conspiracy that were sentenced on the basis of the drug quantity being the entirety of the conspiracy. That's number 1 and your client?
Yes, Your Honor.
Okay, I think your time is up. Thank you.
Thank you.
Cass, good morning.
May it please the Court, Assistant U.S. Attorney Luke Cass on behalf of the government. Your Honor, we have a Type B plea agreement in this case in which the stipulated amount was 2.5 to less than 3.5 kilograms of cocaine. The PSR comes back and when you do the conversions to marijuana, over 241,000 kilograms of marijuana. I would like to begin by
Just so I'm clear, that's true of the PSRs of the other co-defendants.
I'm not sure if it's true, if that calculation was included.
But even if the calculation would be the same.
Would be the same.
For the drugs listed. So the only possible difference is that the actual calculation of the conversion was done, not the evidence of the amounts. That would have been the same in all the PSRs for all the co-defendants.
Yes, Your Honor. The PSR lists in the footnote, I believe it's page 17 or 18, that the estimate is based on a conservative estimate of the Virgilio Davila project alone. And in some ways, this is an atypical drug conspiracy case, because it doesn't involve just one housing project. It was 4 separate housing projects in Bayamon as well as other points. Just to refute the contention that Judge Jose somehow used the Pájaros massacre, that was his ultimate reason for doing this, it helps to look at the chronological sequence of events. November 12th, 2010 is when Mr. Reyes-Santiago changed his plea. The PSR comes out on February 1st, 2012 that lists those drug amounts, same drug amounts. An order comes out, it's docket entry 2595, on February 27th, 2012, in which he says, after careful consideration, the court is not going to consider either the Pitufo murder, which I believe is the one that he was killed outside the courthouse, or the Pajaros massacre. That will not weigh into the court's thinking at all. And I think that statement and the judge's repeated statements during the sentencing hearing is entitled to some weight. You should take him at his word when he says that.
Why would that be brought up in the first place?
Well, Your Honor, this is how it was brought up. At the end of the change of plea hearing, Judge Fuste asked about the defendant's criminal history. I believe that's the first time it comes up. And he made some comments at the end of the change of plea that it's shocking, his criminal history. And the reason the drug amounts became relevant is because the defendant, he signed in his factual statement to the plea agreement that he was the owner of the Boston Red Sox. However, at the change of plea hearing, he refuted that. So the judge says, in order for me to exercise some sort of meaningful sentencing discretion, we're going to address two issues at sentencing. One being the defendant's role in the drug conspiracy, and two, the drug amounts that are properly attributable to him. And that's why he ordered the United States to seat a witness to address those two issues.
So so the precipitating cause of being interested in it was a gap between the allegation in the PSR that he owned the Boston Red Sox and the defendant saying, no, I didn't?
It wasn't in the PSR at that point because it hadn't come out yet. It was his unwillingness to accept that at the change of plea hearing, Your Honor.
So had he accepted that he was the owner, the judge would have accepted the lower quantity, but because he disputed that he was the owner of it, he's now charged with the higher quantity?
I'm not sure if he would have accepted it just on that basis, Your Honor. He seemed interested in the defendant's criminal history and in his role in the offense. But
independent of that.
Independent of that. So I can't say for sure whether...
Could you then explain a little bit why he wasn't interested in the other defendant's stipulations?
Well, Your Honor, when this issue came up, when we sat Mr. Burgos, he gave testimony in which he said that Reyes-Santiago was essentially a lieutenant to the number one, Mr. Colón de Jesus, and he organized shifts, he found workers, he ran a stash house, and he kept the drug conspiracy essentially running for the four different housing projects. He essentially was the COO of this organization, ran it on a daily basis. He also delegated the position. If you wanted a job, he would hire you. So essentially, Your Honor, and that was one of the reasons he gave when he was explaining the sentence. This is a big-time supervisor in a big-time drug trafficking organization that took up a huge part of the territory of Bayamón. And he repeated that it was based on his level of responsibility and the size and scope of the organization.
And how do you explain the other five leaders, why they would be treated as less important than somebody who was not indicted as a leader?
Well, Your Honor, in the appendix, it makes reference to some of these managers and drug point owners. And a lot of times when the case is being indicted, you have 1 through 9, and further evidence comes out later that he actually has greater responsibility than you initially thought he had, which I believe is the case with Mr. Reyes-Santiago. 5, for example, one of the gentlemen
was... a slightly different question. I understand that evidence may have come out that he had greater responsibility than you initially thought he had. My question is, what is the basis for concluding he had greater responsibility than for the other 5 people who were charged as leaders of the conspiracy?
Well, the fact that, Your Honor, that he was working directly with the leader of the organization and the level of the responsibility that was entrusted to him would be, I guess, the response.
Is this something that you knew when the plea agreement was entered into?
I'm sorry, Your Honor?
Did you know this information at the time you entered into the plea agreement?
Your Honor, I was not the trial assistant in this case.
Well, I didn't say you personally. I'm talking about the United States.
We know he was a higher level. I don't believe we did. I'm not sure, Your Honor. I can't.
But the record shows that you must have, because you had the witness waiting outside that you brought in to provide the testimony to the judge. When the judge asked you, what's his responsibility, the government said, yes, we're ready to give you all that evidence. So you must have known he was this level.
Yes, Your Honor. I believe the trial assistant did know that then. This witness was used once before for another sentencing hearing. I believe it was the leader. That was the only other time that he was seated as to these issues.
I'm curious. When you people enter into a plea agreement, is there any duty to defend that plea agreement?
Yes, Your Honor, there is. There's an affirmative duty to recommend what's being promised. I think we see that in the sentencing transcript in this case, where on 5 separate occasions, the AUSA states we stand by the plea agreement, Your Honor. We stand by the plea agreement. And at one point, actually, Judge Cousteau says, no one can say you're breaching because, in essence, I'm forcing you to seek this witness. I want to know about these issues, and I'm making you do this. So short of that, Your Honor, we actually didn't answer the motion for reconsideration until we were ordered to do so, and even then, we stated that we do stand by the plea agreement. So there's numerous occasions in which we said that. I'm not sure. It's a difficult position to be in when you have these twin responsibilities to answer the court and to also abide by your duties.
Was there any was there any discussion between the prosecution and the judge as to how the interrogation, the questioning of the witness should take place, whether the judge, given his concern, should conduct the questioning or whether your office should conduct the questioning?
The Assistant Federal Public Defender actually objected to the judge's preferred method of having the AUSA ask the questions, and he overruled that objection and made us ask the questions.
And it was your preference to conduct the inquiry rather than have the judge do so?
I don't think
your office's preference.
I don't think it was a preference, Your Honor, but I believe it was our understanding that we would seat the witness and ask the questions, that we would control the method of interrogation, Your Honor. And it was limited. Excuse me.
Oh, go ahead. Finish.
I was just saying the judge made sure that he only wanted to hear about role and drug amounts before the actual question took place.
And how long did the questioning go on for?
Your Honor, I believe it's pretty substantial. Let's say it's about 30 pages of the sentencing hearing transcript.
How long time was that? An hour of questioning, or is that?
I believe it was less than an hour, Your Honor.
Less than an hour. And when there's various points at which the defense counsel, on cross-examination, is asking certain questions, and the prosecution objects.
Yes, Your Honor. I noticed that in the transcript.
Yeah.
How
is that consistent with just providing the evidence to the judge?
I don't remember the specific basis for the objections, Your Honor, but I would agree it probably would have been better not to object to affirmatively contest.
And why do you think that would have been better?
Just because it would be more consistent and akin with our duties to follow and abide by the terms of the plea agreement. There's a certain point where we have to fulfill our duty to the court, but I'm not sure the objection was on a substantive issue. But
well, by that logic, when defense counsel sought reconsideration of the sentence, you probably shouldn't have opposed the motion for reconsideration, which you did. Isn't that correct?
We didn't, Your Honor, actually, until the court ordered us to oppose it. He actually ordered the government to respond to it. Initially, we did not file an opposition to it, Your Honor.
He didn't order you to oppose it. He just ordered you to respond.
Government shall we didn't. We actually said we stand by the plea agreement, and we laid out the basis for the various. There's one thing to actively oppose it, but to say that it's errors were committed is another. Notice my time is concluded.
Can I just hold on the sentence? The credit for the 15 months.
Yes, Your Honor.
As I understand your brief, your position is that he got the credit for the year.
He got credit for the year, yes, Your Honor.
Yeah, but that was a separate argument for the year of jail time. He was also asking for a credit for the 9 months served and the 6 months served for the prior revocations of the supervised release. Is that right?
I believe it is, Your Honor.
Okay. What is your argument as to why he shouldn't get the credit for those 15 months, setting aside the year? I just didn't follow what the argument would be. Because it seems like under the statute, there's a cap, and you get the credit for the time served, even though that statute's now been changed. Is there some argument I'm missing?
No, Your Honor. I believe my understanding of the argument was that they had used the wrong guideline that was in effect at the time, which was the 24 to 36 range. My understanding was he was sentenced 2 years consecutive, and he received a year for credit. I can file a supplemental on this issue, Your Honor, if you want me to address it in more detail. Because if he wasn't credited the 9 to 15, certainly we'll take a closer look at that.
Okay, that'd be helpful.
Yes, Your Honor.